I've spoken about the more technical and medical aspects of back injuries, and now we're going to talk about the claims assessment approach to these types of injuries. So I'm going to start off with a basic claims assessment approach. So this is a general guideline that you can follow and you can adapt it to your own company's philosophies. So the first thing we would do is when we receive a claim, we would obviously scan through all the information that we have, and we need to summarize the information that we do have. The most important thing to note is what benefits does the client have on the policy and what benefit definition are we assessing the claim against. And once we know that, we can determine if we need further requirements in terms of what we initially received. It's also very important to check for exclusions on the policy, because if a person has a back exclusion on the policy, we need to know, is it a full back exclusion? Is it just a cervical spine exclusion or a particular region exclusion? And we need to make sure that we have the relevant information to understand if we can use the exclusion or we need to go ahead and assess the claim. So in many exclusion wordings, we have something called an intervening event, which could be a motor vehicle accident or a trauma, and that sometimes discredits the exclusion because you may not be able to prove that the current condition was as a result or made more likely by the initial condition. So we need to make sure we understand all parts of the claim in terms of the policy document and the rules of the benefit, what exclusions were applied, what was the underwriting decision initially. Then what we need to also do, if it's an early claim, when we say early claim, each company defines what an early claim is. Sometimes it's a claim that comes in within the first 2 years of policy commencement, sometimes 3 years, sometimes 5 years. And what we would do is we would go into the client's medical history prior to the underwriting date. So we need to determine that all the information they told us when they took out the policy is all correct and that they didn't omit anything and that the underwriting decision would have been the same. Because should there be a different decision, that would impact the claim and also delay the claims assessment. It's important to brief the client about this upfront because these claims generally take longer and they do result in many complaints. So it's important to make sure you manage the expectation from the outset. If you have enough information to make a claims decision, you can go ahead and do so. It is seldom the case, but it depends on what you're assessing the claim for. If you need to call for information, you need to be able to justify why you need the information, because we don't want to just call for requirements. We know that it's very tedious and it's not an easy task for our clients to get these requirements, and most of them are already unwell. So for them to try and get all these reports is an extra stress on top of their illness. It's also very important for us to make timelines, so we almost understand that each client's story and their journey is unique, and we need to apply this in terms of how we treat the client and how we assess the claim. Once we have a diagnosis, we need to understand if the condition is permanent, depending on the benefit that we're assessing. And we also need to see what sort of treatment the client has had. So have they had optimal treatment and maximal medical improvement? In other words, has their condition reached a level that medication or treatment isn't really going to change the condition from where it is at that moment? We need to be mindful of social circumstances. So is the individual being treated in the public sector or the private sector? Can they get to treatment? All of these things have a huge impact in terms of the ultimate result in their treatment. With regards to disability, there's many factors to consider. The assessment is very complicated and it's not purely based just on the injury or the condition. We need to look at what was the client's employment circumstances, what was their work environment like, is the medical reports that we have in our possession objective, do we have enough time to fully investigate this claim, things like market pressure, manpower, the costs involved in investigating claims preclude us from doing a full and thorough investigation at times. So we need to really understand at the outset which claims need that investigation and which we can quickly finalize and give the client their decision. So I'm going to go into each type of claim because the definitions would dictate how the claim is assessed, and then we can determine what requirements are needed and the philosophy behind each claims assessment principle for the relevant benefits. So for dread disease, some companies have full benefits and some have tiered benefits. Some pay on diagnosis, some pay on having undergone a specific procedure like a spinal fusion, for example. Payment is usually as a result of a trauma if one meets the benefit definition, because not a lot of dread disease specifically covers back injuries as such. It's more covered under impairment, and therefore we need to have all information to ensure that if it was a trauma, we need to confirm did the surgery take place. And it's important to note that for back injuries, it's not a SCIDEP compliant definition. So there's no industry standard in terms of assessing these benefits. We need to follow what the policy says and follow the terms and conditions as set out in the benefit definition to determine if the client qualifies for a claim. In terms of impairment, it's very important to determine if permanency has been established. So with an impairment, we only want to assess these claims once the client has reached maximal medical improvement. If there's any chance for improvement, which is dictated by their treating doctors and specialists, then it's premature to assess the claim, and we'd have to defer the claim until such time that we are sure they've had all possible treatment, and we can then assess the claim according to the benefit. Because you may find some people, when they initially submit a claim, they may qualify then and there for the benefit definition. But if you don't look at the treatment and the situation in terms of the timeline, you could be paying a premature claim, and in the end, it could have been a decline decision. In terms of assessing impairment, each company has their own definitions. A lot of companies use the American Medical Association guides to the evaluation of permanent impairment. Some companies would combine the impairments into one number to get a percentage, and other companies would use individual impairments. So you need to be guided by the benefit definition. Some companies would use activities of daily living to assess the claims, and others have general benefit criteria. So you need to be guided by the policy in terms of impairment, bearing in mind you need all the medicals and specialist reports to come to your decision. When assessing occupational disability, it's important to remember that this assessment is non-medical. I've already mentioned that there's many factors that we must take into account, but the one primary factor is to understand the duties the client performs, what is their education and experience, and what is their age. How does the condition affect the claimant's ability to perform their duties? So, is the duties once again manual? Is it supervisory? Is it more administrative? And we need to link the two. We also need to remember with occupational disability that most occupational disability benefit definitions would require the client to have reached maximal medical improvement and be compliant with treatment. And an important aspect to consider is, are there any psychological overlays? Because those also need to be encompassed into maximal medical improvement before we can assess a claim. So there's various sources of information that we could use. We could do an interview with the client or a job questionnaire, or a worksite visit, which would mostly be done by an occupational therapist, or we could phone their line manager or their human resources department. It becomes a little bit more difficult when the individual is self-employed, because sometimes once they're not working anymore, the business has been dissolved and there's no one that we can get information from. But I think it's important to remember that the primary sources of information come from our clients, and I don't think we phone them enough to find out the facts that we are looking for. I think it's also important to mention that some policies have a change in occupation clause, which means if the client changed occupation or occupational duties, you need to refer to what the policy says, they would have had to notify the insurer to see if the risk to the insurer was still the same, and this could alter possibly the sum assured or the offering of cover. Most people don't know that this clause exists in policies, and we usually land up doing this adjustment at claim stage. People generally non-disclose more manual occupations because the premiums are usually higher for the more manual occupations. So it's important to realize, depending on the information that you have, if you're really struggling to come to a decision, you do have the option, provided you have budget and the sum assured of the policy warrants an independent medical assessment, you could refer the client on to a neurosurgeon, an orthopedic surgeon, a psychiatrist, depending on what your difficulty is with assessing that claim. It's important to remember that those specialists only assess impairment and they cannot give you a decision on the disability. The decision with the disability lies directly with the insurer. Another aspect to consider is a lot of people, especially in our current times, cannot find work, and insurance policies do not ensure the availability of work. They ensure the ability to work. But it does make our job very difficult in terms of speaking to these individuals, because it might be very difficult for an individual who already has an impairment to find work. So we really need to get into the details of the claims assessment to determine what their residual abilities are and if we're making the fair decision for the client.